February 27, 2014, a rehabilitation center in northeast Atlanta. An 89-year-old World War II veteran pressed his call button and said he could not breathe. The nurse told him to stop pressing it and walked out. The only witness was a hidden camera his son had installed, and from there, the case only got worse. These are 10 nurses caught on camera killing patients. Case 1. William George Davis Tyler sits in the eastern pine forests of Texas, a city of roughly 100,000 people built on oil money and cotton fields, and, by the early 2000s, a growing network of hospitals and medical centers that had made healthcare one of its largest industries. It is not a city most people outside Texas could place on a map. It has no particular national profile. What it has is Christus Trinity Mother Frances Hospital, a well-regarded institution with a heart surgery program that drew patients from across the region, and a cardiovascular intensive care unit where the most fragile of those patients went to recover once their operations were done. A cardiovascular ICU is a particular kind of place. The patients there have already been through something extraordinary. Their chests have been opened, their hearts stopped and restarted, their bodies rerouted through machines while surgeons worked. By the time they arrive in the SVICU, the hard part is supposed to be over. They are on the other side. The monitors that surround them track every rhythm and pressure and oxygen level. Nurses move through the unit in shifts, checking lines and readings and making small adjustments. And the work is precise and demanding, but the expectation, the reasonable and well-founded expectation, is that the patients will slowly get stronger. The heart heals, the numbers stabilize, people go home. That expectation held at Christus Trinity Mother Frances through most of 2016 and into the early months of 2017. Then, in the summer of 2017, it stopped holding. Patients who had come through their procedures in reasonable shape began experiencing sudden and severe neurological events. They went from stable to catastrophic without warning. Colleagues noticed it. The nurses working other shifts noticed it. Physicians noticed it. And the thing they noticed most was that they could not explain it. Christopher Greenaway was 47 years old. He had undergone a heart procedure and was in recovery in the CVICU when something went wrong. The same pattern would repeat with John Lafferty and then Ronald Clark, and eventually with a 58-year-old man named Joseph Kalina on the morning of January 25, 2018. All of them were in the CVICU recovering from cardiac procedures. All of them, in the words that would later be used in court, were on the path to recovery before their conditions collapsed. The hospital's physicians were the first to find a clue. When they ran CT scans on the patients who had deteriorated, they found something that should not have been there. Air. Air inside the brain, causing the kind of damage a stroke leaves behind. The official medical term is cerebral air embolism. It occurs when air enters the circulatory system and travels to the brain. It can happen during certain procedures if something goes wrong, but the surgeons who had operated on these patients were certain it had not gone wrong during their work. A heart surgeon named William Turner would later testify that it was inconceivable, given the procedures performed, that air could have entered the patient's systems during their operations, which meant the air had entered afterward, in the recovery unit, introduced through the arterial lines that ran from the patient's bodies to the monitoring equipment. An arterial line is a thin catheter inserted into an artery, typically in the wrist or the groin. It allows continuous monitoring of blood pressure and provides access for blood draws. It is also, if someone wanted to cause harm, a direct opening into the bloodstream. A syringe full of air, pressed into an arterial line, would send a large bubble through the circulatory system toward the brain. The damage would look exactly like what these patients had experienced. Investigators from the Tyler Police Department reviewed staffing and payroll records from the SVICU. They mapped every shift, every nurse, every date and time that a patient had suffered a sudden episode. The pattern that emerged pointed consistently in one direction. A single nurse had been assigned to the unit on every occasion. His name was William George Davis, and he was 33 years old. Davis had grown up in Longview, Texas, about 40 miles from Tyler. He had trained as a registered nurse and eventually found work in the cardiovascular ICU at Christus. To his colleagues, he was capable and experienced. He knew the unit, knew the equipment, knew the particular demands of caring for patients immediately after cardiac surgery. There was nothing in his professional record that would have flagged concern. He had previously worked at a hospital in Longview, and investigators would later note that some unexplained patient deaths had occurred there during his time, though charges were only ever brought for what happened in Tyler. The camera footage changed everything. At the beginning of 2018, the CIVICU at Christus Trinity Mother Francis upgraded its security camera system and installed additional cameras throughout the unit. The expansion was logged as a routine security measure. The cameras recorded in motion-activated bursts, capturing footage whenever someone moved within their field of view. A regional security officer named Robert Graham would later testify about the system at trial, explaining its parameters and its coverage. The cameras were new, they were functional, and what they captured in the early morning hours of January 25, 2018 would eventually be played for a jury in a courtroom in Tyler. Joseph Kalina had come through his cardiac procedure and was being monitored in the CIVICU. A nurse named Wendy Stone, who worked in the unit, later testified that Kalina had been recovering normally. His vitals were stable. There was no reason, medically, to anticipate a crisis. The security footage from that morning shows a sequence of events that would become central to the prosecution's case. Nurse Ben Raspberry is seen walking in at one point. Then Davis enters Kalina's room. He stays briefly, and he leaves. Within minutes of his departure, Kalina's condition begins to deteriorate sharply. Other nurses are called. The monitors tell the story in real time. Stone testified that Davis, rather than joining the response, remained at a distance as his colleagues worked to stabilize Kalina. The investigators reviewed that footage alongside the footage from incidents involving the other patients. The pattern was the same each time. Davis entered the room, Davis left, and the patient's condition rapidly worsened. Investigators would state in the arrest affidavit that the review of security footage showed Davis entering the rooms of 3 patients who suffered sudden episodes within minutes of his departure. He was the only nurse consistently assigned to the unit at the dates and times when those episodes occurred. Davis was suspended and then dismissed from the hospital in February 2018. He was arrested in April. The charges were capital murder, which in Texas can be applied when a single defendant kills more than one person. Prosecutors would eventually charge him with the deaths of 4 patients: Greenaway, Lafferty, Clark, and Kalina. They also accused him of seriously injuring at least 5 more patients and suspected him of being responsible for as many as 11 victims in total. Though the difficulty of proving causation in cases where the method was so difficult to detect meant charges were filed for only 4 deaths, Davis pleaded not guilty. His attorneys, throughout the proceedings, argued that he was a scapegoat. The defense's position was that the hospital itself bore responsibility, that its procedures and negligence had caused or contributed to the deaths, and that Davis had been assigned blame because he happened to be present. They challenged the forensic conclusions and questioned whether the prosecution had properly established what caused the air embolisms. They also raised, at one point, a secondary theory that Davis had been deliberately keeping patients in the hospital longer in order to earn overtime pay, not that he intended to kill anyone. The prosecution responded that no similar episodes had occurred in the CIVICU after Davis was removed from the unit, while the hospital continued using the same procedures and equipment. The trial began in September 2021 at the Smith County Courthouse in Tyler. The jury heard from nearly 24 medical experts, including cardiologists and surgeons who walked through the physiology of air embolism and explained in detail why the air found in the patient's brains could not have originated during their operations. They heard from the nurses and physicians who had been present during the incidents, who described what they observed and when. They heard from security personnel about the camera system, and they watched the footage itself, including the recording from January 25, 2018, showing Davis entering and exiting Kalina's room in the minutes before the patient's condition crashed. The lead prosecutor, Chris Gatewood, told the jury in closing arguments that Davis had gone into those rooms deliberately. He said Davis had done what he did because he wanted to. Gatewood argued that Davis returned to those rooms knowing what he had caused and watching it unfold. The defense maintained to the end that the evidence was circumstantial, that the camera footage showed proximity but not proof, and that the hospital had failed to rule out alternative explanations for the patient deaths. The jury deliberated for approximately 1 hour. On October 19, 2021, William George Davis was found guilty on all 4 counts of capital murder. The verdict came after a month-long trial with dozens of witnesses. 8 days later, on October 27th, the jury sentenced him to death. Davis was transferred to the Allen B. Polunsky unit in Polk County, which houses male death row inmates in Texas. His legal challenges did not end with sentencing. In 2025, his attorneys filed a petition seeking to have the conviction overturned, citing multiple grounds including the subsequent arrest of one of his trial attorneys on unrelated charges. The argument was that his representation had been compromised. Texas courts reviewed those claims. In March 2026, the Texas Court of Criminal Appeals issued its ruling. The conviction and the death sentence were affirmed. The appeals court addressed each of the defense's arguments and rejected them. The court noted, in its opinion, that in every instance, the patients had been on the path to recovery when Davis injected air into their arterial systems. The imaging had confirmed brain damage consistent with air embolism in each case. The security footage had placed Davis at the scene in each incident. No similar events had occurred after his removal. 4 families had brought their relatives to Christus Trinity Mother Frances Hospital for heart procedures. Christopher Greenaway was 47. John Lafferty and Ronald Clark and Joseph Kalina came through their surgeries in reasonable shape and went to the CVICU to recover. What happened to them there was documented in part by cameras that had only just been installed. Whether Davis acted for reasons of control or attention or something else entirely was never formally established. He did not take the stand. His motive, as stated at trial, remained something the prosecution attributed to him based on behavior rather than statement. What the cameras did establish, and what the jury accepted, was where he was and what followed. He remains on death row in Texas as of the summer of 2026, having exhausted his first round of appeals without success. The CVICU at Christus Trinity Mother Frances continued operating. The hospital, facing civil lawsuits from the families of victims and injured patients, reached settlements in several cases. The security footage that helped build the criminal case also became a central exhibit in those civil proceedings. The families of the 4 men who died never received a clear explanation of why. Prosecutors offered their theory that Davis went into those rooms deliberately and that he did what he did because he wanted to. Whether that is the complete picture or only the part of it that could be proven beyond a reasonable doubt is a question that outlasts the verdict. The cameras recorded what they recorded. 4 patients went in for heart surgery and did not come out. 1 nurse was present each time. That was the gap at the center of the case, and the footage was what closed it. Before we move on, if you're enjoying this analysis, please consider subscribing. It helps the channel tremendously. From a hospital security camera in East Texas, we move to a rehabilitation center outside Atlanta, Georgia, where a son's decision to hide a small camera inside a clock radio captured something that would change state law and send 3 nurses to prison. Case 2. Lois Agyeman James Dempsey was 89 years old. He had served in the United States military during the Second World War, part of a generation for whom that service was not a talking point, but simply a fact of biography, something done and then folded into a life that continued afterward for decades. He had grandchildren. He had a son named Tim who visited regularly and spoke with him often. He was, by the accounts of people who knew him, mentally sharp. He did not have dementia. His mind was clear, which matters here because of what he would eventually tell his son about what was happening to him while he was in the care of others. In early 2014, Dempsey underwent hip surgery. Hip surgery at 89 is serious but not unusual. Recovery takes time. The expectation, as it was communicated to his family, was that he would spend time in a rehabilitation facility while his body healed, and then he would go home. His family had made preparations. Tim Dempsey later described purchasing a modified van and arranging a hospital bed for his father's return. They were ready for him to come back. The plan was to bring him home. He was admitted to the Northeast Atlanta Health and Rehabilitation Center in Brookhaven. The facility was a licensed skilled nursing and rehabilitation center of the kind that exists in almost every American city, staffed by nurses and aides working rotating shifts, serving patients who were recovering from surgeries or managing chronic conditions or transitioning between hospital care and independence. Most of its residents were elderly. Most of them were, by the nature of why they were there, vulnerable. Dempsey settled into the facility and began his recovery. But at some point in the weeks that followed, he started saying things to his son that Tim could not ignore. He described strange things happening to him there. He said he was not being cared for properly. The specific nature of his complaints, the exact words he used, were the kinds of things a family member hears and then cannot easily dismiss, not when the person speaking them is elderly and dependent and has no way to document what is happening to them. Tim Dempsey faced a situation that is familiar to an enormous number of families with elderly relatives in care facilities. He could not be there around the clock, and he did not know what happened in that room when he was not present. He could visit, he could ask questions, he could observe, but he could not watch continuously. His father could tell him things, and those things could be true, or they could be misremembered, or exaggerated by age and medication and the disorientation of illness. There was no way to know without a witness. He decided to place a camera in the room. He did so with his father's knowledge and permission. The device he used was small, hidden inside a clock radio on a surface in the room. Dempsey knew it was there. He had agreed to it. Tim went over the situation with him, made sure he understood, and set up the equipment in a way that would not be immediately obvious to staff. For a period of time, the camera recorded ordinary activity. Nothing that Tim reviewed from those recordings answered the question of whether his father's concerns were founded. Then February 27, 2014 arrived. James Dempsey began the day complaining of chest pain. He told nursing staff that he could not breathe. These are not symptoms to be dismissed in an 89-year-old with a recent surgical history, a person whose cardiovascular system is already under stress from age and recovery. Chest pain and difficulty breathing in that context demand immediate attention. They are the kinds of symptoms that send nursing staff reaching for blood pressure cuffs and oxygen monitors and, if the numbers are wrong, for the phone to call a physician. What the camera recorded was something different. A nurse named Lois Agyeman came into the room. She was a licensed practical nurse, 62 years old, with what records would later indicate was substantial experience in nursing. She did not check Dempsey's vital signs when she entered. Instead, she told him that there was nothing wrong with his heart. She told him to stop pressing his call button. Then she left the room. Dempsey pressed the call button again. A nursing assistant named Mabel Turman arrived 24 minutes later. She found him unresponsive. She went to get help. Agyeman returned to the room and found her patient no longer responding, no longer conscious, no longer able to tell anyone what he was feeling. The appropriate response in that situation, the response that every trained nursing professional is taught and that nursing boards across the country require, is to begin cardiopulmonary resuscitation if the patient has no documented order declining it. Agyeman did not begin CPR. She left the room again, this time to look for documentation of a do not resuscitate order. A DNR is a legal document, signed by the patient, that instructs medical staff not to attempt resuscitation. It is an important document in end-of-life care, and checking for one, before beginning CPR, is a legitimate step in certain circumstances. But Dempsey was not a patient in end-of-life care. He was a man recovering from hip surgery who was expected to go home to a family that had purchased a modified van for his return. He had no DNR on file. He had explicitly said he wanted to be saved if something went wrong. Agyeman was gone for approximately an hour. During that time, James Dempsey was dying in the room behind her. When she finally confirmed that no DNR existed, Agyeman returned. A third nurse, a licensed practical nurse named Wanda Knuckles, had also arrived. The prosecution would later argue that both Agyeman and Knuckles, having allowed so much time to pass, then performed CPR only after emergency services were called, as a performance for the arriving paramedics, rather than as a genuine attempt to save him. The words that the DeKalb County District Attorney's Office used in court was that it was a ruse staged for the emergency personnel who had just arrived on scene. James Dempsey died on February 27, 2014. He was 89 years old, and he had survived the Second World War. His family had a room ready for him at home. The footage from the clock radio camera recorded all of it. Tim Dempsey and his family reviewed the video in the aftermath of their father's death and understood what they were looking at. They filed a civil lawsuit against the Northeast Atlanta Health and Rehabilitation Center. The litigation moved slowly, as civil cases often do, and the footage existed, but had not yet reached the attention of law enforcement or the wider public. That changed in 2017. A television station in Atlanta, Russia, which operates as 11 Alive, had an investigative team called The Reveal. The team came across the Dempsey case in the course of their reporting and obtained the hidden camera footage. What they found was hours of video, including the sequence from February 27th showing Dempsey in respiratory distress, pressing his call button, begging for help, being told to stop, being left alone. They also uncovered video depositions taken as part of the civil case, in which the nurses involved gave accounts that were inconsistent with what the footage showed. The 11 Alive report aired and drew significant attention. It was the kind of investigative journalism that closes the loop between private wrongdoing and public consequence. The Brookhaven Police Department, whose jurisdiction covered the facility, launched a criminal investigation based on what the television reporting had surfaced. The investigation reviewed the camera footage, the nursing records, the depositions, and the medical documentation surrounding Dempsey's death. A grand jury convened in DeKalb County and returned indictments in 2018. Lois Agyeman was indicted on charges of felony murder, which carried the possibility of a life sentence. Wanda Knuckles was charged with concealing the death of another person. Mabel Turman faced charges of neglect of an elder person and concealing a death. The legal proceedings that followed were complicated almost immediately by a question that had implications far beyond the Dempsey case. The nurses' attorneys filed a motion to exclude the hidden camera footage from trial. Their argument was that the recording had been made without the nurses' knowledge or consent, and that its use violated the privacy rights of the nursing staff. The nurses, the defense attorneys contended, had a reasonable expectation of privacy in their professional setting, and the footage should therefore be inadmissible. The question worked its way through the Georgia court system over the following 2 years. Lower courts addressed it without definitively resolving it. In 2020, the Georgia Supreme Court took up the case and issued a ruling that would become a significant legal precedent. The court held that the families of nursing home residents have the right to place video recording equipment in their loved ones' rooms to monitor the care being provided. The footage, the court ruled, was admissible. The decision was grounded in a recognition of the fundamental vulnerability of residents in care facilities and the practical difficulty of monitoring the care they receive through any other means. The ruling did not stop the prosecution, but it did extend the timeline. By the time the cases moved toward resolution in early 2022, roughly 8 years had passed since James Dempsey's death on that February morning. In February 2022, Mabel Turman entered a guilty plea to charges of neglect of an elder person and concealing the death of another. A judge sentenced her to 5 years of probation, recognizing that she bore the least direct responsibility among the 3 defendants. She had arrived to find Dempsey already unresponsive, had not herself turned him away while he was asking for help. The following month, in March 2022, Lois Agyeman and Wanda Knuckles appeared before DeKalb County Superior Court Judge Shondiana Morris. Agyeman entered a guilty plea to involuntary manslaughter, neglect to an elder person, and concealing the death of another. The felony murder indictment, which had framed the most serious version of the charges against her, was resolved through the plea agreement. She was sentenced to 8 years in prison. Knuckles pleaded guilty to a single count of concealing the death of another person and was sentenced to 1 year in prison. Members of James Dempsey's family attended the court proceedings. Tim Dempsey, the son who had placed the camera in his father's room, spoke afterward. He said that no outcome in a courtroom would bring his father back. He said he hoped the case would send a message to care facilities and their staff. He said that maybe they had saved some other families from what they went through. The impact of the case extended beyond the sentences handed down in that DeKalb County courtroom. The Georgia Supreme Court's 2020 ruling on the admissibility of hidden camera footage became part of the foundation for new state legislation. Georgia joined a growing number of states in formally establishing the right of nursing home residents and their families to use video monitoring equipment. The Dempsey case was among the incidents that demonstrated why such protections were necessary, and the legal argument about the footage, which had been fought all the way to the state's highest court, had produced a ruling that now gave other families a clearer legal footing. Ohio had experienced something similar. A woman named Esther Piscor spent the final years of her life in a nursing home in Cleveland, where her son Steve grew suspicious of the care she was receiving. He installed a hidden camera in her room, and the footage showed aides mistreating her, yelling at her, handling her roughly, neglecting her. Esther Piscor died in 2018, but her son spent years working with Ohio legislators. The law that resulted from that effort, signed into effect in 2022, is known as Esther's Law. It gives nursing home residents in Ohio a legal right to have monitoring equipment in their rooms. The Dempsey case and the Piscor case represent 2 points in a broader pattern, families discovering through private surveillance what formal oversight mechanisms had failed to catch. There is a particular quality to the footage from Dempsey's room that made it impossible to set aside once it was seen. He was an 89-year-old man, not confused, not incapacitated mentally, experiencing something real and frightening, and asking for help in the plainest possible terms. He pressed a button designed for exactly that purpose. The button is there so that patients who cannot get up or raise their voice above a certain volume can still reach someone. He pressed it, and he told the nurse what he was feeling. She told him his heart was fine. She told him to stop pressing it. She left. He pressed it again. The camera in the clock radio recorded all of this. Tim Dempsey had placed it there because he trusted what his father told him about the care he was receiving, and he wanted to be able to see what he could not see himself. What he recorded ended up closing a case that might otherwise have been documented only as a natural death at the end of a long life. A man in his late 80s recovering from hip surgery dies in a rehabilitation facility. That is the kind of death that generates a form to be filed, not an investigation to be launched. The camera made the difference. The camera was the reason that what happened to James Dempsey on February 27, 2014, became something more than a line in a record. Lois Aguiman was released after serving her sentence. Mabel Turman completed her probation. The facility where the events took place, the Northeast Atlanta Health and Rehabilitation Center, operated under different leadership after the case concluded, with administrators stating publicly that standards of care had been improved in the years since. The building is still there in Brookhaven, still operating as a care facility, still receiving patients who are too fragile to be at home and not sick enough to be in a hospital. James Dempsey never made it back to the van his family had waiting for him. Before we move on, if you're enjoying this analysis, please consider subscribing. It helps the channel tremendously. From a rehabilitation center outside Atlanta, the story moves across the Atlantic and into the far north of Germany, where a nurse spent 5 years killing patients in hospital intensive care units in order to perform acts of heroism in front of his colleagues, and where a single witness, catching him in the act, would eventually unravel the worst chapter of medical murder in modern German history. Case 3. Niels Högel Delmenhorst was smaller, closer to Bremen, the kind of town that drew no particular attention from outside its borders. Between these two unremarkable places, in a period of roughly 6 years that began around the turn of the millennium, somewhere between 85 and 300 people died at the hands of a single nurse. The difficulty in stating the number precisely is part of what makes this case distinct from almost any other. The confirmed figure, the one a court found proven beyond reasonable doubt, is 85. The number suspected by investigators, based on the broader pattern of deaths during the relevant years, is considerably higher. Some estimates reach into the mid-200s. The bodies of many potential victims were cremated before any suspicion arose, which means the evidence was gone before anyone thought to look for it, and so the question of how many people Niels Högel actually killed will never have a final answer. What the court in Oldenburg established in June 2019 is that it was at least 85, and that the manner of those deaths was deliberate, repeated, and done in pursuit of something that the judge described, when he read the verdict, as incomprehensible. Högel was born in Wilhelmshaven in December 1976, in a family with a background in nursing. He trained as a nurse and, by the late 1990s, was working in intensive care units in northern Germany. Intensive care is among the most demanding environments in nursing. The patients are the most fragile, the margins for error are the smallest, and the work requires a particular combination of technical skill and calm judgment under pressure. Högel appeared to possess those qualities, at least to the people who worked alongside him in his early years. Colleagues described him as confident, capable, someone who responded readily when emergencies arose. He volunteered for difficult situations. He stepped forward when others hesitated. That quality of stepping forward was not, as it turned out, a straightforward expression of competence or dedication. What Högel was doing, beginning at the Oldenburg Clinic where he worked from 1999 to 2002, and continuing at the hospital in Delmenhorst where he transferred in 2003, was manufacturing the emergencies he was responding to. The method was pharmaceutical. He had access, through his position in intensive care, to a range of heart medications that are used in specific clinical circumstances and that require careful dosing because of their potency. Drugs like agmaline, amiodarone, and sotalol act on cardiac rhythm. Lidocaine is a common anesthetic but also has cardiac effects at higher doses. Potassium chloride, in sufficient quantities, stops the heart. Högel took these medications, administered them without prescription to patients in his care, and then positioned himself to respond to the crisis he had created. He would rush to begin resuscitation. He would work on the patient while colleagues gathered. Sometimes he succeeded in reviving them. Often he did not. The psychological architecture of what he was doing has been described and analyzed at length in the years since, by psychiatrists who testified at his trials, and by journalists who covered the case. The working explanation that emerged from court proceedings was that Hergel was driven by a need for recognition and status that he could not obtain through ordinary means. The praise that comes when a nurse successfully resuscitates a patient is immediate and visible. It is something a colleague sees happening in real time. Hergel, according to this account, needed to be seen performing those acts of rescue, and so he created the situations that would allow him to perform them. The patients who died were the cost of that need, in the calculation that ran somewhere behind whatever it was he thought he was doing. He admitted, at various points across multiple trials, that this was broadly true. In his 2018 court appearance, when the full scope of the charges was laid before him, he told the judge that the characterization of the charges was, more or less, accurate. He had induced cardiac arrest in patients. He had then tried to revive them. He had not always succeeded. He said he was honestly sorry. He said he hoped the families of his victims would find some peace. The survivors' relatives were in court that day. Many of them had been waiting years for a proceeding of this kind, and some of them had been waiting for an answer to a simpler question: how had this been allowed to go on for so long? At the Oldenburg Clinic, colleagues testified that they had noticed something unusual about the patterns during Hergel's shifts, but had not moved decisively to report it. Death rates among intensive care patients are not stable from shift to shift, and there are many possible explanations for variation. The patients in an ICU are already in precarious condition. They decline. They die. Working out which deaths are the result of illness and which are the result of something else requires looking at data across a long period and then making a decision to act on what the data suggests. At Oldenburg, the decision to act did not come in time. Hergel was effectively allowed to leave that post without a formal complaint being made to police. He moved to the hospital in Delmenhorst in 2003, and his colleagues there became suspicious of him faster. The spike in emergency situations during his shifts was pronounced enough that, according to later court testimony and investigative reporting, staff at Delmenhorst discussed among themselves what might be happening. The hospital administration became aware of the concerns. Internal reviews were conducted. None of those internal processes resulted in a call to police until after the moment in 2005 when everything changed. In June 2005, a colleague at the Delmenhorst Hospital walked into a patient's room while Hergel was present. What the colleague witnessed was Hergel in the act of injecting an unprescribed medication into a patient's intravenous line. The drug was Adjmalene. It had not been ordered by any physician for that patient. There was no clinical reason for it to be administered. The colleague who saw what was happening reported it to the hospital. Hergel was suspended from duty. He was taken off the ward. The patient he had been injecting was still alive when the colleague walked in. That patient died the following day. 2 days passed before anyone contacted the police. The delay was later identified as one of several institutional failures in the case, a moment when earlier action might have preserved evidence or prevented the concealment of what had already happened across 6 years of shifts. When police were eventually notified, they had the incident at Delmenhorst to investigate. A colleague had witnessed a nurse injecting an unprescribed drug into a patient, and that patient had died. The charges that followed were attempted murder, because at the time of the injection, the patient was still alive. Hergel was convicted in 2008 of 1 count of attempted murder and sentenced to 7.5 years in prison. That should have been the end of it. In the sense that he was in prison and no longer working in a hospital, it was the end of his ability to harm patients. But the scale of what he had done over the preceding years remained unknown. Hergel was serving time for a single attempted murder. Families of patients who had died in Oldenburg and Delmenhorst during his time at those hospitals had no idea that their relatives' deaths might be connected to the man now in prison. During the period leading up to his 2015 trial, in which prosecutors brought charges related to the deaths of patients in Delmenhorst, Hergel told investigators something that dramatically expanded the scope of the case. He said he had killed more. He gave a number in the range of 30 patients whose deaths he acknowledged. He said the decisions had been relatively spontaneous. He could not remember the details of all of them. That admission set in motion an investigation of a kind that had rarely been attempted in German criminal history. Prosecutors and police established a special commission. They obtained court orders to exhume the bodies of former patients. Over the following years, more than 130 bodies were exhumed from cemeteries across Germany, and in some cases, from burial sites in Poland and Turkey, where deceased patients had been transported home for burial by their families. The remains were tested for traces of the cardiac medications Hergel had admitted using. The scale of the exhumation process The logistics of tracking down former patients' families and obtaining permissions and coordinating forensic examinations across international boundaries was an undertaking that took years and required cooperation between multiple German states and foreign authorities. In 2015, a court in Oldenburg found Högl guilty of 2 murders and 2 attempted murders relating to the Delmenhorst period and gave him his second life sentence. He was already serving 1. The new sentence meant he would not be eligible for release under German law until he had served a minimum term that, given his age and the accumulation of convictions, effectively meant he would die in prison. But the exhumation process continued regardless, because the legal question was not only about Högl, it was also about what had been allowed to happen and why, and about whether anyone else bore criminal responsibility for the failures that had allowed him to keep working through years of mounting suspicion. Those questions would eventually lead to further criminal proceedings against hospital administrators and colleagues in Delmenhorst, who had been aware of concerns about Högl but had not escalated them to law enforcement. That trial, addressing the question of institutional negligence, was separate from the question of what Högl himself had done, but the 2 threads ran in parallel for years. The major trial, in which Högl faced 100 counts of murder, opened in October 2018 in the Oldenburg District Court. The building where proceedings took place was not large enough to accommodate the families of all potential victims, and a satellite venue was arranged so that relatives could follow the proceedings via video link. An estimated 126 relatives were listed as co-plaintiffs, a legal category under German law that allows victims' family members to participate in criminal proceedings in a more active capacity than mere witnesses. Högl entered the courtroom each day and took his seat. He had aged since his first arrest. He covered his face from cameras in his earlier appearances, but by the time of this final trial had largely stopped trying to obscure himself. He wore ordinary clothes. He spoke when spoken to, and, in a statement that opened the trial, acknowledged broadly that the charges were accurate. He said he was sorry. A psychiatrist who evaluated him found traits consistent with a personality disorder, but concluded that he was legally responsible for his actions, that his mental state did not reach the threshold under German law that would mitigate criminal culpability. The proceeding ran for months. Judge Sebastian Buermann and a panel heard from dozens of witnesses, reviewed toxicological reports from the exhumed remains, and worked through each of the 100 counts individually. In 15 of those counts, the evidence was insufficient to support a finding of guilt. Högl himself said he could not remember the circumstances of many of the incidents, which meant that his own acknowledgement could not fill the gaps where physical evidence was thin. On June 6, 2019, Judge Buermann read the verdict. Niels Högl was guilty of 85 counts of murder. The judge spoke for some time before delivering the number. He described reviewing the evidence as the work of an accountant of death, a phrase that captured the mechanical weight of processing so many individual killings within a single legal proceeding. He told Högl that his guilt was incomprehensible, that the human mind struggled to take in the scale of what had been placed before the court. Högl was sentenced to life imprisonment for the 3rd time, with the court specifying the particular gravity of the crimes in a way that, under German law, signals that a minimum term review should not result in early release. He was 42 years old when the sentence was passed. He is currently serving that sentence at a facility in Germany. The victims ranged in age from 34 to 96. They had been admitted to hospital intensive care units for a wide variety of reasons, and most of them had some underlying illness that made them vulnerable. That vulnerability was part of why the deaths had passed unnoticed for as long as they did. A sick person dying in an ICU does not automatically raise questions. The pattern had to become dramatic enough that the numbers alone demanded an explanation, and even then, the response from institutions was slower than it should have been. The colleague who walked into that room in Delmenhorst in 2005 and saw what Högl was doing was the mechanism that eventually ended it. Not a camera, not an algorithm, not a formal audit, but a person walking through a door at the wrong moment and paying attention to what was happening. That moment of ordinary observation stopped him from harming further patients in that unit. It did not immediately account for the years that came before it, and the accounting that followed required a decade of investigation, exhumations, and 3 separate criminal proceedings before the full scope of what had happened was formally established. Whether the number is 85 or something substantially higher, the families of those patients in Oldenburg and Delmenhorst buried people they believed had died of illness. Some of them later learned that this was not what happened. Others never will because the evidence no longer exists. It was cremated before anyone thought to look. Before we move on, if you're enjoying this analysis, please consider subscribing. It helps the channel tremendously. From the hospitals of northern Germany, the story moves to a dialysis clinic in a small city in East Texas, where two patients sitting in their treatment chairs watched a nurse prepare a syringe, and what they saw prompted them to speak up in a room full of people who could all hear what they were saying. Case 4, Kimberly Sayen's dialysis is not a treatment for something temporary. It is a long-term replacement for kidneys that have failed or are failing, organs that can no longer perform the essential work of filtering waste and excess fluid from the blood. Patients who need dialysis typically come to a clinic several times a week for sessions that last several hours each. They sit in reclining chairs while their blood is drawn out through a needle, passed through a machine that performs the filtration their kidneys cannot, and returned to their bodies cleaned. It is slow and exhausting and entirely necessary. Without it, the waste products that the kidneys would normally remove build up in the blood until the body can no longer function. Dialysis patients are, by definition, chronically ill. Many of them are elderly. Most of them are there, not because something went wrong once, but because something went wrong at a fundamental level, and will not be going right again. The clinic is not a place they chose, it is a place they have to be. The DaVita Clinic in Lufkin served that community of patients. They came in on their scheduled days and settled into their chairs and were cared for by the nursing and technical staff. For most of them, the clinic had become as familiar as any regular appointment. The same faces across the room, the same staff members hooking up their lines. That familiarity is part of how dialysis clinics work. The patients know the nurses know the patients. The relationship builds over months and years of the same routine, the same conversations, the same careful management of the same fragile conditions. Kimberly Clark Sayens had arrived at DaVita through a path that should have raised more concern than it did. She had grown up in Massachusetts and relocated to East Texas in adulthood, eventually pursuing nursing certification at Angelina College in Lufkin. She had also worked previously as a veterinary technician, a job that had given her experience with administering medications to animals, including controlled substances. Her nursing career before DaVita had been marked by serious problems. She had been employed at Woodland Heights Hospital in Lufkin and had been fired there under suspicion of stealing Demerol, a powerful opioid painkiller. At the time she started at DaVita in 2007, she was already under investigation by the Texas Board of Nurse Examiners for that alleged theft. The investigation was ongoing. The board had not yet acted. DaVita hired her. She was assigned to work with patients undergoing dialysis treatment. She handled the lines and the machines, administered medications, and monitored patients during their sessions. Bleach is used routinely in dialysis clinics, mixed with water to disinfect the plastic tubing and other equipment between patients. It is a standard cleaning agent in that environment. The presence of bleach in the clinic, in small containers and buckets kept around the treatment area, was unremarkable. It was simply part of the way the space was maintained. The first signs that something was wrong appeared in the early spring of 2008. Patients at the Lufkin Clinic began experiencing serious medical events during their sessions. On April 1, 2008, a patient named Fran Metcalf went into cardiac arrest while receiving treatment. Within 30 minutes, a second patient, Clara Strange, also went into cardiac arrest. Two patients collapsing in the same session was far outside anything the staff had seen before. Both women died. The clinic launched an internal investigation, but could not identify a clear cause. Over the following weeks, more patients experienced cardiac events during their sessions. Some survived. On April 16th, a man named Garlin Kelly Jr. suffered cardiac arrest and died. On April 22nd, two more patients were affected. One of them, a woman named Cora Bryant, died from what her family later described as an extreme and inexplicable deterioration in a patient whose condition, before her dialysis session that day, had been stable. 5 patients dying in a dialysis clinic over the course of a few weeks is not something that passes without question. The clinic's own medical director was involved in reviewing the deaths. Investigators from the facility examined the equipment, the procedures, the cleaning protocols, and the records. No equipment failure was identified. No contamination of the water supply was found. No common pathogen was detected. The deaths clustered around certain sessions and certain days, but the pattern, while clearly present, was not yet pointing anywhere specific in the way that would compel a definitive response. Then came April 28, 2008. 2 patients were in the treatment area that day, seated in their chairs and hooked up to their dialysis machines. They were not medical professionals, but they were regular attendees at the clinic, and they knew the routines. They knew what should happen and what should not. One of them, a woman named Linda Hall, was watching the room when she noticed Kimberly Sands crouch down near a cleaning bucket that held bleach solution. What Hall saw was Sands take a syringe, draw liquid from that bucket into the syringe, and then walk to the chair of another patient and inject the contents of the syringe into that patient's IV tubing. The other patient who witnessed what happened, a woman named Lurleen Hamilton, was watching as well. She saw Sands go to a second patient after the first and repeat the same process. The husband of that second patient began calling out in distress, asking what was wrong with his wife, asking what had been done to her. Both witnesses were frightened. Hall would later describe the state she was in as she processed what she had just seen, the awareness that she was assigned to this nurse, that whatever had been done to the patients across the room was something that could be done to her. Hamilton's reaction was immediate and direct. She told staff that she did not want Sands to touch her anymore. The 2 women went directly to Amy Clinton, who was the charge nurse at the clinic that day. They told her what they had seen. Clinton took their accounts seriously. She went to Sands and asked her about it. Sands told Clinton that she had been using bleach to clean the lines of an unused dialysis machine and had been using a syringe to measure the bleach precisely, which she said was standard practice for that task. Clinton knew that using a syringe for bleach measurement was not company protocol. She sent Sands home. Clinton then went to the bucket and to the syringes that Sands had been seen using. She tested them. Every one of them came back positive for bleach. The bucket, the syringes, the materials Sands had been handling in the presence of the 2 witnesses all confirmed the presence of bleach in concentrations and containers consistent with what the witnesses had described seeing injected into the IV lines. The 2 patients who had been at the receiving end of Sands' actions that day did not die. They became seriously ill, with dangerous fluctuations in blood pressure, but they survived. The fact of their survival did not diminish the significance of what had happened. They had been injected with a substance that had no clinical purpose in their treatment, and that their bodies were now struggling to process. Investigators from local law enforcement were brought in. The clinic's sharps containers, which hold used syringes and needles and are collected over a period of weeks before being properly disposed of, were taken as evidence. Across multiple weeks of discarded syringes from the facility, a significant number tested positive for bleach. The evidence was not limited to April 28. It suggested a pattern of contamination going back further, consistent with the timeline of the deaths and cardiac events that had been occurring since the beginning of April. Then investigators discovered a detail that would become one of the most significant pieces of evidence in the case. A syringe had been labelled with the name of a patient named Opal Few. Opal Few was one of the patients who had died. The syringe, which should have contained her prescribed medication, was found to contain bleach. It was not a cleaning syringe in a general collection. It was a syringe marked with a specific patient's name, meant to hold a specific medication, and it held something that should never have been in a patient's body. The investigation also retrieved records of Sands' internet searches in the period around the deaths. She had searched, using terms that investigators characterized as deliberate research, for information about whether bleach could be detected in dialysis lines. She had found sources suggesting it could not be detected. The prosecution's argument at trial was that this search was not casual curiosity or innocent concern, but evidence that Sands had looked into whether her method would be traceable and had concluded, incorrectly as it turned out, that it would not be. The background that investigators assembled on Sands added further context to the picture. The firing from Woodland Heights for suspected Demerol theft, the ongoing nursing board investigation at the time she was hired by DeVita, a history that included domestic instability and financial difficulties. The prosecution did not need a stated motive in order to convict, but the pattern of her professional history suggested a person who had moved through healthcare settings, leaving a trail of problems that institutions had failed to connect to each other. Sands was arrested in April 2009, roughly a year after the events at the clinic. The charges were capital murder, reflecting the deaths of 5 patients: Clara Strange, Fran Metcalf, Garlin Kelly Jr., Cora Bryant, and Opal Few. She also faced aggravated assault charges in relation to the patients who had survived after being harmed. She pleaded not guilty. The defense's position throughout the proceedings was that Sands was being made a scapegoat for the clinic's own failures. that DeVita had operated the facility with inadequate procedures and that the deaths and injuries were the result of those systemic problems rather than anything Saenz had deliberately done. Her trial began in the spring of 2012 in Angelina County. It was a long proceeding. The prosecution built its case on the testimony of the 2 eyewitnesses who had watched her at the cleaning bucket on April 28th, on the forensic evidence from the syringes and sharps containers, on the syringe labeled with Opal Few's name, on the internet searches, and on the medical evidence connecting each patient's sudden deterioration to exposure to bleach during their dialysis sessions. Expert witnesses testified about the clinical effects of bleach when introduced into a dialysis line, about the way it would behave in the bloodstream and the organs, and about why the deaths were consistent with that kind of poisoning rather than with natural deterioration in sick patients. Linda Hall took the stand and described what she had witnessed in the treatment room that April morning. She described seeing Saenz crouch, draw from the bucket, cross to a patient's chair, and inject the syringe into the IV tubing. She described her own fear in the moments after. Lurleen Hamilton testified to the same sequence from her position in the room. Their accounts corroborated each other on the essential points: the bucket, the syringe, the injection, the patient's husband crying out. Saenz did not testify. The defense maintained that the witnesses were mistaken or lying, that the bleach in the syringes had an innocent explanation, and that the clinic's water systems or cleaning procedures were the real source of any contamination. The jury did not accept those arguments. She was convicted of capital murder. The jury, in the sentencing phase, was asked to consider whether to recommend the death penalty. They did not. Kimberly Saenz was sentenced to life in prison without the possibility of parole. The 2 patients who watched her from across the treatment room on April 28 had done something that, in the context of a dialysis clinic, required a particular kind of courage. They were ill. They were dependent on the staff around them for treatments they needed to survive. Speaking up about what they had seen meant describing a member of that staff, in that environment, to the charge nurse in charge of managing that same staff member. They did it anyway. Within hours of their accounts reaching Amy Clinton, Saenz had been sent home. Within days, the syringes were tested. Within a year, she was arrested. The families of Clara Strange, Fran Metcalf, Garling Kelly Jr., Cora Bryant, and Opal Few had brought their relatives to a dialysis clinic for routine treatment. That treatment was keeping them alive in the most direct possible sense. What was introduced into their IV lines instead was what killed them. Investigators and prosecutors believed Saenz may have been responsible for additional patient deaths beyond the 5 she was charged with, but the standard of proof required for a criminal charge meant the case was built around the deaths for which the evidence was clearest. She remains in a Texas prison. The DeVita Clinic in Lufkin closed in the aftermath of the case. The building where the treatment chairs once stood is no longer a place where dialysis patients sit. Before we move on, if you're enjoying this analysis, please consider subscribing. It helps the channel tremendously. From the dialysis clinic in East Texas, the story moves to the intensive care units of 2 New Jersey hospitals, where a nurse spent 16 years killing patients with injections of heart medication, and where investigators finally caught him only after a colleague agreed to wear a wire and have a conversation that she knew might break her. Case 5. Charles Cullen. Somerset County has hospitals that serve its population the way any mid-sized American county does. Institutions built to handle the medical needs of the communities around them, and staffed by professionals who move between shifts and go home and come back, and are largely invisible to the people their work is meant to serve. It was in one of those hospitals, Somerset Medical Center in Somerville, that the investigation into Charles Cullen finally came together in 2003, 16 years after the killing had begun. 16 years is the number that sits at the center of this case, and that gives it its particular quality of institutional failure. Cullen was not a difficult man to suspect. Over the course of his career, he worked at no fewer than 9 hospitals in New Jersey and Pennsylvania, and at almost every one of them something went wrong. Patients died at elevated rates during his shifts. Suspicious circumstances were noted. Internal reviews were conducted. Colleagues raised concerns. In several cases, formal investigations were initiated by hospital administrations or by prosecutors' offices. And at the end of almost every one of those processes, Cullen was quietly allowed to resign, or was let go without a formal report being made to law enforcement or to the nursing board, or had his employment terminated in a way that generated no record that would follow him to the next institution. He moved on. He was hired again. The patients at the next hospital did not know what had happened at the previous one. Cullen was born in West Orange, New Jersey, in 1960, the youngest of 8 children in a family that experienced significant loss when he was young. His father died when he was an infant. Several siblings died in the years that followed. He dropped out of high school and eventually joined the United States Navy, where he served for several years before receiving a discharge. He then enrolled in nursing school at Mountainside Hospital in Montclair, graduating in 1987. His first nursing job, at a burn unit in New Jersey, was also the beginning of his first known killing. A patient named Judge John Yengo Sr. died while under his care that year, under circumstances that were later reviewed with suspicion, though a formal determination about that death was never made. The method he used across the years that followed was pharmacological. He administered medications to patients at doses intended to kill. The drug he used most consistently was digoxin, a heart medication that at therapeutic doses helps regulate cardiac rhythm and at overdose amounts causes fatal arrhythmia. He also used insulin, which at high doses drives blood sugar low enough to cause irreversible brain damage and death. Both drugs are present in hospital settings as standard medications. Both require careful management even in clinical use. Both, if administered without appropriate indication or at doses far beyond what any patient needed, would kill. What made Cullen difficult to catch was the nature of his victims. He worked in intensive care and critical care units, environments where the patients were already seriously ill, where death was not unusual, where the physiological disruption caused by a drug overdose could present in ways that overlapped with the natural deterioration of a sick person. A patient dying of a digoxin overdose could look, to an initial clinical assessment, like a patient dying of cardiac failure, which was already the reason many of them were there. The deaths required careful forensic analysis to distinguish from natural causes, and that analysis was not always performed, or was performed and interpreted in ways that did not trigger an investigation or triggered a review that stopped short of a criminal referral. By 2003, Cullen was working in the critical care unit at Somerset Medical Center in Somerville. He had been at the hospital for about a year, having previously worked at Sacred Heart Hospital in Allentown, Pennsylvania, from which he had been let go after a co-worker discovered a cache of unused medications in a waste bin. The drugs had no recreational value and no reason to be there. Cullen was identified as the source and fired in June 2002. An investigation by the Lehigh County District Attorney's Office looked into multiple deaths during his tenure at Sacred Heart and found that he had been present at more than 50% of them, despite working only a fraction of the available hours. The investigation ran for 9 months and then was closed due to insufficient evidence. No referral was made to the State Nursing Board. At Somerset Medical Center, the sequence of events that ended his career and his freedom began with a patient named Jin Kyung Han, who suffered a non-fatal overdose of insulin in August 2003. The circumstances were suspicious enough that hospital administrators notified local detectives. 2 investigators, Tim Braun and Danny Baldwin, began looking at the patient deaths and injuries that had occurred on Cullen's shifts. What they found in the hospital's electronic medication dispensary records was striking. Somerset Medical Center, like many hospitals by the early 2000s, used a computerized system to track and dispense medications. Nurses accessing the system logged their identity each time they withdrew a drug. The system recorded every transaction. When Braun and Baldwin reviewed those records, they found that Cullen had been accessing medications for patients who had not been prescribed those medications, withdrawing doses that had no documented clinical purpose. He had been reaching into the system and taking out drugs that had no business being in anyone's hands for the patients in question. The records did not show him injecting anyone with anything, but they showed a pattern of access to drugs at times and in quantities that were not explained by any treatment order. This kind of electronic paper trail was something earlier hospitals had not had, or had not used consistently, or had not known how to interpret when the records were available. The computerized dispensary system at Somerset gave investigators something specific and documented to work with, a record of Cullen's movements through the pharmacy that did not depend on witness accounts or physical evidence that might have been disposed of. The detectives also discovered that a patient at Eastern Hospital in Pennsylvania, where Cullen had previously worked, had died after receiving what appeared to be an inappropriate dose of the same heart medication found in records from Somerset. The pattern was extending backward, connecting the earlier hospital to the present one through the same method and the same drug. But the records, while compelling, were not by themselves enough to arrest Cullen. What detectives needed was something that would close the gap between what the pharmacy records suggested and what they could prove had happened. The plan that emerged involved a woman named Amy Loughran. Loughran was a nurse at Somerset Medical Centre. She and Cullen had become friends since he joined the unit. She was a single mother raising 2 young daughters, working night shifts while managing a serious heart condition of her own. By her later account, Cullen had been kind to her, had watched her children when she needed someone to, had covered for her when her health made working difficult. She thought she knew him. When investigators approached her and told her what they suspected he had done, she was at first resistant and disbelieving, and then, as the detectives walked her through what the evidence suggested, increasingly unable to dismiss it. Loughran agreed to help. What she agreed to was not a small thing. She agreed to wear a recording device, concealed on her body, and to go and speak with Cullen about the deaths at Somerset. The conversation would be captured on the recording. Whatever he said, whatever he acknowledged or implied or failed to deny, would be preserved as evidence. The meeting took place at a bar in Bridgewater, New Jersey. Investigators set up surveillance outside in the parking lot. Loughran went in and sat with Cullen, a man she had worked alongside for a year, a man who had been present at her worst moments on night shift and who she had trusted. She brought the conversation around to the deaths at the hospital. She told him she knew. She told him she thought he had done it. She said they should go to the police together. Cullen did not confess in the explicit terms a prosecutor might have wished for, but he did not deny. He told her he could not. He said the words twice. He said he could not go to the police with her, could not do what she was asking, and then he left the bar. Investigators were waiting in the parking lot. The recording had captured the exchange. It was enough for probable cause, and Cullen was arrested outside the bar that night. He was taken into custody on December 12, 2003. In the days that followed, he began talking. He told investigators that he had killed patients. He gave names and hospitals and approximate timelines. He spoke about his motivations in ways that were later parsed carefully by journalists and prosecutors and the families of victims. He said he thought he had been helping people. He said he believed his patients were suffering and that he had been easing that suffering. He said this while investigators were establishing that many of his victims had not been terminally ill, had not been in pain in any clinical sense, had been people who came to the hospital for treatment of a condition from which they could reasonably have expected to recover. He pleaded guilty in multiple counties in New Jersey and Pennsylvania. The cases were prosecuted sequentially, each county bringing its own charges for the deaths that had occurred within its jurisdiction, and Cullen entered guilty pleas in each proceeding. The total number of deaths he admitted to in formal proceedings was 29. Law enforcement and medical experts who reviewed the records of his career believed the number was far higher. The estimate that circulated most widely was that the actual death toll could be in the hundreds, possibly approaching 400, though definitively establishing a cause of death connection for patients who had died years earlier in institutions that had not retained records, or whose bodies had been cremated or buried without autopsies, was not practically possible. Cullen himself gave inconsistent numbers at different points, sometimes saying he had killed around 40 people, and at other times acknowledging that he did not know exactly how many. In 2006, the sentencing proceedings in New Jersey concluded. Cullen received 11 consecutive life sentences in that state. Pennsylvania added further sentences. In total, he was ordered to serve 18 consecutive life terms, ensuring that regardless of any parole consideration, he would die in prison. His earliest possible parole date, as listed by the New Jersey Department of Corrections, extends into the 24th century. He appeared on the television program 60 Minutes in 2013, his first and, as far as public records show, his only extended interview. He spoke with the journalist Steve Croft for over an hour at the New Jersey State Prison in Trenton. He confirmed that he had killed people. He said he was sorry. He said he did not know whether he would have stopped if he had not been caught. And he gave that answer with a directness that was difficult to reconcile with the image of the quiet, helpful colleague Amy Loughran had described. He said the motivation had been, in some form, a feeling that he needed to do something, that he felt overwhelmed, and that what he did was not an answer to anything. He could not explain it in terms that satisfied the question. The case generated significant attention beyond the immediate criminal proceedings because of what it revealed about the healthcare system that had allowed Cullen to move between institutions for 16 years. A book published in 2013 by the journalist Charles Graeber examined the case in detail, tracing the sequence of hospital investigations that had failed to produce a referral to law enforcement and the informal agreements between institutions that effectively transferred Cullen to the next employer without disclosure. The book, and the Netflix documentary and film adaptations that followed it over the subsequent decade, focused considerable attention on Amy Loughren and on what her decision to wear a wire had cost her personally. Loughren had worked alongside Cullen not knowing, and then had agreed to record him knowing what the recording was for. Her role in his capture was significant in a direct and practical sense. The conversation in the bar was the mechanism that gave investigators probable cause for his arrest. Without it, the electronic dispensary records might have been enough eventually, but the timeline was uncertain. The wire moved things forward. She later described the experience in interviews and public appearances, and went on to work as a nurse practitioner while also speaking about the case. Her account of who Cullen appeared to be, how he presented to those around him, became part of the public record of what the case revealed about the gap between professional appearance and what someone might actually be doing. Somerset Medical Centre implemented changes to its medication tracking and review processes in the aftermath of the case. Several other hospitals involved in Cullen's employment history were named in civil litigation brought by victims' families. New Jersey eventually passed legislation addressing the requirements for healthcare institutions to report suspicious employee conduct to authorities rather than managing departures quietly. The specific failures that allowed Cullen to keep working, the gap between internal review and formal criminal referral, the absence of any shared record system that would allow a new employer to know what had happened at the last one, became the subject of policy discussion at a state and national level. None of that discussion brought back the people who died under his care. 29 deaths were formally established in court. Each of those patients had gone to a hospital because they were sick and needed treatment. Several of them were recovering well at the time they died. A judge at one of his sentencing hearings, reading the list of names and circumstances, said that the fundamental betrayal at the heart of the crimes was not only the harm done to individuals, but the destruction of something essential in the relationship between a patient and the people caring for them. Cullen continues to serve his sentences at the New Jersey State Prison. He was 63 years old in 2023. No credible information has emerged suggesting he has any avenue toward release. The recording made in the bar in Bridgewater, the device hidden on Amy Loughren's body while she sat across from a man she had considered a friend, is part of the evidentiary record of the case. It captured the moment when the gap between 16 years of suspicion and a criminal arrest finally closed. Before we move on, if you're enjoying this analysis, please consider subscribing. It helps the channel tremendously. From the hospitals of New Jersey and Pennsylvania, the story crosses back to the Pacific, to a dialysis ward in Yokohama, Japan, where a nurse decided that the most efficient solution to a problem she found emotionally uncomfortable was to make her patients die on someone else's shift. Case 6. Ayumi Kuboki. Ayumi Kuboki was 28 years old in 2016 and had been working at Oguchi Hospital for approximately a year. She was a registered nurse assigned to a ward on the 4th floor, a floor that handled the most acutely ill elderly patients. She worked rotating shifts, sometimes days and sometimes evenings, managing the lines and medications of patients who had, in most cases, been admitted with the understanding that their conditions were beyond cure. Her colleagues described her in various terms after her arrest. She had not been warmly regarded by all of them. The atmosphere on the ward during her time there was troubled in ways that went beyond her specifically, but that would later be seen in context with what she had been doing. In August 2016, before the deaths began, the ward experienced a strange sequence of incidents. Nurses' uniforms were found ripped or damaged. Drinks belonging to staff members were found to have been tampered with, a foreign substance mixed in. These incidents frightened and unsettled the nursing staff, and they were reported internally, but no perpetrator was identified at the time, and no formal investigation produced an answer. The incident stopped. Whatever had been happening on the ward in August came to an end without resolution. Nobody was publicly linked to the ripped uniforms or the spiked drinks. Then, in September, the deaths began. On September 15, 2016, a patient named Sozo Nishikawa died. He was 88 years old and had been receiving treatment on the 4th floor. His death was attributed initially to his underlying condition. 2 days later, on September 17th, another patient on the same floor, Nobuo Yamaki, also 88, died. His death was also processed as a natural outcome for a patient of his age and condition. The hospital's documentation moved forward, as it does in facilities of this kind, recording the death and notifying the appropriate parties. Then something happened that changed the trajectory of the case. A nurse working on the ward picked up a saline IV bag from the treatment trolley and noticed immediately that it looked wrong. The liquid inside the bag was foamy. Saline solution is clear. It does not foam. The bag also carried a smell that the nurse recognized. It was the sharp chemical scent of benzalkonium chloride, which is a disinfectant used in hospital cleaning and in some topical antiseptics. It is not an ingredient of saline solution. It had no business being inside an IV bag. The nurse set the bag aside and reported it. Hospital staff examined other bags. They found, in multiple bags, small holes pierced through the protective filter that sealed the rubber stopper. The holes were the kind made by a fine-gauge needle, the type of needle on a standard medical syringe. Somebody had taken a syringe, loaded it with disinfectant, and injected the contents into sealed IV bags that were then placed back on the trolley for use with patients. The contamination was not an accident, and it was not equipment failure. It had been done deliberately, and the bags were there to be used on whoever happened to need one next. The hospital contacted the Kanagawa Prefectural Police on September 20th, 2016. The report triggered a criminal investigation, but the investigation faced an immediate challenge. The disinfectant used, benzalkonium chloride, is a substance that breaks down in the body and is not easily detected post-mortem unless testing is conducted relatively quickly after death. Nishikawa had already been buried. Police obtained his body just before cremation could occur and conducted an autopsy. The results confirmed the presence of benzalkonium chloride in his system. When investigators checked the body of Yamaki, the same substance was found. Both men, it was now clear, had died not of natural deterioration, but of deliberate poisoning. The investigation that followed was broad and painstaking. 48 patients had died at Oguchi Hospital between July and the end of September 2016, a number substantially higher than what the facility would typically see in that period. 5 patients had died on a single day in late August. 4 had died on a single day in early September. Investigators reviewed all of those deaths, attempting to identify which ones might be connected to deliberate contamination and which represented the ordinary toll of serious illness in an elderly population. The difficulty was the same difficulty that faces any investigation of this kind in a geriatric care setting. The baseline death rate was already high, which meant that deliberate deaths could sit within the statistical noise of natural mortality without triggering immediate concern. Investigators worked through patient records, shift schedules, access logs, and whatever physical evidence remained. The disinfectant used in the contaminations was stored in various locations throughout the hospital for cleaning purposes. Establishing who had access to it was not straightforward because, as is typical in hospital environments, it was widely accessible to staff. No single control point existed where access could be easily monitored. Kuboki had left Oguchi Hospital by the time the criminal investigation became public. She had given multiple interviews to Japanese television networks in late 2016, shortly after the poisonings became known. In those interviews, she denied any involvement. She presented herself as a former employee of the facility who had heard about the terrible events there and had no knowledge of what had caused them. The interviews were broadcast nationally. She was not at that point under arrest or formally identified as a suspect, and her television appearances positioned her as an outsider, commenting on a tragedy rather than its source. Investigators spent nearly 2 years developing the case. The challenge of building a prosecutable charge against a specific individual in a case where the disinfectant was commonly available throughout the hospital, where the contaminated bags had been handled by multiple staff members, and where the deaths had occurred in a setting that routinely produced high mortality, required careful and systematic work. Investigators reviewed the overlaps between staff schedules and the timing of deaths, the patterns of which shifts saw elevated mortality, the access records for the cleaning supplies and medications on the ward. When Kuboki was arrested in July 2018, nearly 2 years after the deaths at Oguchi Hospital, she was no longer working there. She had taken a position at another healthcare facility. Her arrest became major national news in Japan, in part because of the television interviews she had given in 2016 and the dramatic gap between how she had presented herself then and what investigators were now saying she had done. Under questioning, she admitted to it. Her admission was specific and, to the people who heard it, almost incomprehensible in its stated reasoning. She told investigators that she had targeted patients because she wanted them to die when she was not on duty. She found the process of explaining a patient's death to their bereaved family members emotionally burdensome. The conversations that followed a death, the communication with grieving relatives at the bedside or on the telephone, was something she experienced as a form of stress she did not want to manage. Her solution, as she described it to investigators, was to administer the disinfectant to patients she believed were already close to death, timing the dosage in a way she calculated would cause their deaths during a shift she was not working. She said she had done this to approximately 20 patients. The court ultimately convicted her of 3 confirmed murders: Sozo Nishikawa, Nobuo Yamaki, and a third patient named Asae Okitsu, who was 78. Those were the deaths for which the physical evidence and the toxicology met the standard required for a criminal conviction. The other patients whose deaths investigators suspected were connected to her actions could not be prosecuted to the same standard. For the same reasons that dogged the investigation from the beginning, many of the bodies had been cremated, the disinfectant was difficult to detect post-mortem, and establishing individual causation in a high-mortality environment required evidence that simply did not exist in many cases. The Yokohama District Court convicted her in November 2021. She had pleaded guilty. The judge noted that she had shown remorse, and the court declined to impose the death penalty that prosecutors had requested. She was sentenced to life imprisonment. Prosecutors had argued that the scale of the suspected harm, even accepting only the 3 confirmed deaths, and the calculated nature of the crimes, warranted the maximum penalty available under Japanese law. The court weighed the mitigating factor of her guilty plea and her expressed remorse against the gravity of what she had done, and came down on the side of life imprisonment rather than death. The Tokyo High Court reviewed the case in 2023 and upheld the life sentence. Kuboki's appeals did not succeed in modifying the outcome. She is serving her sentence in Japan. The case raised serious questions about oversight and accountability at Oguchi Hospital. The 48 deaths during the summer and early autumn of 2016 represented an anomaly that, in hindsight, should have prompted an earlier and more urgent response. The strange incidents in August, the ripped uniforms and the tampered drinks, had been reported internally but not to police, and not connected at the time to any specific individual. Had those incidents been investigated more aggressively and linked to Kuboki before the September deaths, the outcome for at least 3 patients might have been different. The patients she chose were already dying in the clinical sense, already at the stage where their families had accepted that the hospital was providing comfort rather than cure. She selected them on that basis, reasoning that a death in that context would be less likely to provoke scrutiny than the sudden collapse of someone expected to recover. The logic was both calculated and wrong. The foamy 4 bag, the smell of disinfectant where there should have been clear saline, the needle holes in the rubber filters, all of it was visible to the nurse, who happened to pick up the right bag at the right moment. That observation and the chain of reporting it set in motion is what pulled the case out of the statistical background noise of a geriatric ward and into a criminal investigation. Asae Okitsu was 78. Sozo Nishikawa and Nobuo Yamaki were both 88. They were in a hospital in Yokohama because they were ill and needed care. The care they received in their final hours was not what any of them or their families had agreed to when they were admitted. Before we move on, if you're enjoying this analysis, please consider subscribing. It helps the channel tremendously. From the geriatric wards of Yokohama, the story moves back across to the United Kingdom, to a hospital in Stockport in the north of England, where a nurse spent months contaminating saline bags and medical supplies with insulin, leaving the poisoning to chance, and to whichever patient happened to receive a contaminated product next. Case 7. Victorino Chua. Victorino Chua came to Stepping Hill from the Philippines via the United Kingdom's recruitment of overseas nurses, a pathway that brought thousands of Filipino healthcare workers into the NHS over the years, when staffing shortages made international recruitment a practical necessity. He had trained as a nurse in the Philippines and had been working in British healthcare settings before arriving at Stepping Hill. By the time the events of 2011 unfolded, he had worked on the hospital's acute medical wards for long enough that he was a familiar presence, a father of 2 daughters who lived in Heaton Norris nearby and worked the night shifts on wards A1 and A3. Night shifts in an acute medical ward are their own particular world. The volume of activity drops, the supervisory presence is reduced, the long corridors grow quiet in the early hours, and the handful of nurses working through until morning manage their patients largely without the overhead of the daytime structure. Medications are administered, observations are checked, emergencies are managed as they arise. The treatment rooms off the wards hold the supplies that make all of this possible. Saline bags in various sizes, ampules of saline used to flush cannulas and lines, insulin for the diabetic patients who need it, the various components of the pharmaceutical toolkit that a nurse reaches for dozens of times in a shift without thinking much about it. The supplies sit in those rooms because they need to be accessible. Accessibility is the point. In June and July of 2011, somebody began using that accessibility as a weapon. The contamination, when investigators eventually understood what had been happening, was methodical in a particular way. The person responsible had taken saline bags and saline ampules from the treatment room supply, used a fine-gauge hypodermic needle to pierce through the protective filter sealing the rubber stopper, and injected insulin into the bags and ampules. The insulin dissolved invisibly into the saline solution. The bags and ampules were then placed back into the supply, indistinguishable from the uncontaminated stock surrounding them. Other nurses coming to the treatment room to collect what they needed for their patients would reach for a bag or an ampule without any reason to suspect that what they were picking up was not what it appeared to be. They would take it to a patient's bedside and administer it, following the normal protocols for the normal reasons, and the patient would begin receiving insulin they had not been prescribed, in a quantity that could drop their blood glucose to dangerous levels. The clinical effect of an insulin overdose is hypoglycemia, a catastrophic fall in blood sugar. Glucose is the primary fuel for brain function. When blood glucose drops too low, the brain begins to fail. The patient sweats, becomes confused, loses consciousness. The process can move quickly, and if it is not recognized and treated promptly with glucose, the outcome can be irreversible brain damage or death. In a ward full of patients who are already ill for other reasons, a sudden hypoglycemic episode does not immediately announce itself as the result of deliberate poisoning. It presents as a medical emergency requiring urgent response, and the clinical team responds to the emergency without necessarily stopping to ask why it has occurred. This was the nature of the contamination. It was randomized in the sense that it did not target specific patients. Whoever happened to receive a contaminated product happened to be poisoned. The judge who sentenced Chua would later describe this quality of the crime as strikingly sinister and truly wicked, precisely because Chua had removed himself from the act of harming individuals and placed the selection of victims entirely in the hands of chance. He prepared the contaminated products and left them to be used by his colleagues on whichever patient presented the next clinical need. The deaths and injuries accumulated during June and July 2011. Tracy Arden was 44 years old. She had been admitted to Stepping Hill and was receiving care on one of the affected wards when she was given contaminated saline. She died. Alfred Weaver was 83 years old. He too received a contaminated product during his admission, and he too died. A 41-year-old man named Grant Massell received contaminated saline and suffered a hypoglycemic episode severe enough that the resulting oxygen deprivation to his brain left him with permanent and serious brain damage. He survived, but the life he had before that admission did not survive with him. A patient named Arnold Lancaster was also poisoned. He was in his 70s and was suffering from terminal cancer when he was admitted to Stepping Hill. He experienced hypoglycemia and became gravely ill. The jury at Chua's eventual trial cleared him of Lancaster's murder, concluding that the evidence did not meet the threshold of proof required for the most serious charge, given Lancaster's underlying terminal condition and the difficulty of establishing causation beyond reasonable doubt. They convicted Chua of causing him grievous bodily harm with intent, which the judge treated as a finding consistent with deliberate poisoning, regardless of whether that poisoning could be proven to have caused the death. In all, 14 patients at Stepping Hill received saline or ampules contaminated with insulin. Beyond the deaths and the brain injury, others survived after receiving medical treatment for their hypoglycemia. The scale of what was happening became impossible to ignore by July 11, 2011, when an alert nurse working on Ward A3 picked up a saline ampule from the treatment trolley and noticed immediately that something was wrong. The liquid inside had a foamy quality. Clear saline does not foam. The ampule also carried a smell, the distinct, disinfectant-adjacent scent of synthetic insulin, a compound with a recognizable chemical odor that a nurse familiar with administering it would know. She did not administer the ampule. She put it down, told more senior staff what she had observed, and the reporting chain that followed brought the contamination fully into the open. The response from the hospital and from Greater Manchester Police was extensive. Investigators collected the contaminated products for forensic analysis, confirming the presence of insulin in the saline. Ward operations were reviewed. The police came close, by the account of the Greater Manchester Chief Constable speaking afterward, to shutting down sections of the hospital entirely to protect patients. The chief constable said later that the reason they did not was the calculation that moving very frail patients to other facilities carried its own risk of death, and that closing the hospital might cause the same harm it was meant to prevent. A nurse named Rebecca Layton was arrested early in the investigation and spent time in custody under suspicion. She was subsequently released, and the charges against her were dropped as the investigation's focus shifted. Layton was entirely innocent of the contaminations, but her arrest illustrated how difficult the early phase of the investigation was. Working from a situation where multiple staff members had access to the treatment rooms, where the contaminations had been done at times that were not witnessed, and where establishing who had prepared the poisoned bags required an investigation that worked backward through shifts and access patterns and records. The discovery of a letter changed the trajectory of the investigation. The letter was handwritten and was found at Chua's home in Heaton Norris when investigators searched the property. In the letter, Chua described himself in terms that the prosecution placed before the jury as evidence of a mind that understood what it was doing and had articulated something of its character. He wrote that there was a devil in him. He wrote that he was an angel who had turned into an evil person. The letter was not addressed to anyone and did not function as a confession in the direct operational sense, but it described a self-awareness that was difficult to account for innocently. Chua's employment history at Stepping Hill and the pattern of his night shifts were mapped against the timeline of the contaminations and the patient incidents. Prescription records were reviewed for any alterations. The forensic work continued to build the picture that the prosecution would eventually present to a jury at Manchester Crown Court. The trial opened in early 2015. Chua pleaded not guilty. His defense team argued throughout the proceedings that he was not responsible for the contaminations and raised the possibility that someone else on the ward had been the source. The prosecution countered with the physical evidence from the contaminated products, the records of who had access to the treatment rooms, the pattern of incidents relative to Chua's shifts, and the letter found in his home. A handwriting expert gave evidence about the letter. Medical experts testified about the clinical effects of insulin overdose and the manner in which the contaminations had been achieved. The jury deliberated for 11 days before returning its verdicts. Chua was found guilty of murdering Tracy Arden and Alfred Weaver. He was acquitted of the murder of Arnold Lancaster, but convicted of causing him grievous bodily harm with intent. He was convicted on 22 counts of attempted grievous bodily harm, 1 count of grievous bodily harm relating to Grant Mizell, and a range of further counts relating to the tampering with medication products. He showed no emotion as the verdicts were delivered. The sentencing judge, Justice Openshaw, addressed Chua directly when imposing punishment. He said that Chua had used his experience and knowledge as a nurse to poison people randomly, that his actions had been strikingly sinister, in the specific sense that he had not administered the insulin himself to most of his victims, but had left the distribution of harm to whichever colleague reached into the treatment room next. He noted the case of Jack Beeley, 72, who the evidence suggested Chua had targeted specifically to silence a patient Chua had found troublesome. Justice Openshaw said the action toward Beeley had been indescribably wicked. Chua received a minimum term of 35 years. The judge calculated that Chua would be 84 before he could be considered for parole, an age at which, the judge noted, the practical question of release would be almost entirely theoretical. He was taken down from the dock without expression. The victims' families gave statements outside the court. The families of Tracy Arden and Alfred Weaver described the years since the deaths as a prolonged absence that the verdict did not resolve. Grant Mizell, whose brain injury had altered the entire course of his life, was represented by family members who described how the man they had known before July 2011 had not been recoverable by any medical intervention since. The Greater Manchester Chief Constable later apologised publicly to Rebecca Layton for her arrest and for the ordeal she experienced while under suspicion. The apology acknowledged that the early investigation had proceeded on the basis of insufficient evidence connecting her to the crimes, and that her detention had caused her significant harm. Layton later received compensation and spoke about her experience, describing the particular difficulty of being suspected of something inside a profession where your reputation is your identity. The foamy ampule that the nurse on Ward A3 noticed and set aside on July 11, 2011, was the moment the contamination campaign ended. Whatever Chua intended to do beyond that point, the nurse's observation that something was wrong with what she had picked up from the trolley set the investigation in motion. The hospital's stock was secured, the wards reviewed, and no further contaminations occurred. 14 patients had already been harmed by that point. 2 of them did not survive to see the verdict. Before we move on, if you're enjoying this analysis, please consider subscribing. It helps the channel tremendously. From the acute wards of a Manchester hospital, the story moves to the nursing homes of Western Pennsylvania, where a registered nurse spent 3 years moving between 5 different facilities and administering lethal doses of insulin to patients in the early hours of the morning, timing her actions to ensure the consequences would fall on someone else's shift. Case 8. Heather Presti. Heather Presti grew up in Natrona Heights, a small community in Allegheny County not far from Pittsburgh. She had worked earlier in her life as a veterinary technician, a profession that involves, among other tasks, the administration of medications to animals and, when the situation calls for it, the clinical management of an animal's death. She eventually pursued a career in nursing and obtained her registered nurse license, entering the healthcare workforce through the network of long-term care facilities across the western counties of the state. Her first nursing job was at Encompass Health Rehabilitation in Harmarville, where she began in October 2018. She stayed for about 6 months. Before she left, the facility disciplined her for the improper use of insulin. The discipline was recorded. She departed and moved on to another facility. Over the next 4.5 years, Presti worked at 4 more facilities: Concordia at Rebecca Residence, Bel Air Healthcare and Rehabilitation, Quality Life Services in Chicora, Premier Armstrong Rehabilitation and Nursing Center, and Sunnyview Nursing and Rehabilitation Center in Butler County. The facilities were spread across multiple counties, which meant that each hiring institution was looking at an applicant with nursing credentials and a work history, not at a pattern that connected all 5 employers and what had been happening during her shifts at each one. The discipline at Encompass Health for insulin use was in her record, but it had not produced a referral to the Pennsylvania Board of Nursing that would have flagged her to subsequent employers in a way that made the pattern legible. Insulin is used in nursing home settings to manage blood glucose in diabetic residents. It is a drug that requires careful dosing because the consequences of getting the dose wrong, in either direction, are serious. Too little, and a diabetic patient's glucose remains uncontrolled. Too much, and the patient's blood glucose drops, potentially to levels that cause unconsciousness, seizure, and if left untreated, death. The clinical management of insulin in a nursing home environment requires the nurse to know which patients are diabetic, what their prescribed doses are, and when those doses are to be given. It is not a drug that should be administered to a patient who has not been prescribed it. Presti administered it to patients who had not been prescribed it. She also administered it to diabetic patients in doses far beyond their prescriptions. She did this primarily during overnight shifts, when staffing was lowest, and the immediate clinical response to a deteriorating patient was slowest to arrive. She timed what she did, according to the account investigators later assembled from her own admissions and from the pattern of incidents across her career, to ensure that the consequences would become apparent after her shift ended. If a patient received a lethal dose of insulin at 2 in the morning, the body's decline would unfold across the subsequent hours. By the time the medical emergency was visible to clinical staff, the nurse who had caused it would, in most cases, no longer be the nurse in the building. This timing was deliberate. Presti told investigators, after her arrest, that she had taken steps to ensure her victims would deteriorate before a shift change, so that they would not be sent to a hospital where medical testing might reveal what had been done to them. The emergency that played out in front of the oncoming staff was presented as an unexplained medical event in a patient who was already elderly and already ill. In a nursing home environment, the death of an elderly resident during the night is not, in itself, an event that automatically triggers a criminal investigation. It is, for the staff and administrators who process it, a familiar and expected kind of loss, documented and reported to the appropriate parties and absorbed into the ongoing work of the facility. She also told investigators that she had sometimes returned to check on a patient who had received an excessive dose and, if the patient appeared to be recovering rather than declining, had administered a second dose to ensure the outcome she intended. The method required her to be present, to monitor, to make judgments in real time about whether what she had done was producing the result she wanted, and to intervene again if it was not. This was not passive neglect. It was active and sequential. Her co-workers, at multiple facilities across the years, raised concerns. They questioned her conduct. They observed that she spoke about her patients with contempt, making comments that described them in ways that had no place in a professional environment. One account that later emerged from investigators described Presti telling a colleague that a particular patient would be better off dead. Text messages retrieved during the investigation included exchanges in which she described wanting to harm the people in her care, writing to her mother that she was going to murder her aides and that she might kill a specific resident in order to establish some kind of boundary with someone she found difficult. Her legal team later characterized some of these messages as figures of speech, expressions of frustration in the hyperbolic register that people sometimes use when venting privately. The prosecution took a different view, placing those messages within the broader pattern of what the evidence showed she had actually done. The case that eventually brought Presti into the justice system began at Quality Life Services in Chicora, a nursing facility in Butler County. In May 2023, investigators received information about suspicious patient outcomes at the facility. A patient identified in court documents by the initials JB was a nonverbal resident who had been hospitalized twice in 2022 after experiencing dangerous drops in blood sugar. That patient died on December 4, 2022. A second patient at the same facility had also died under circumstances that prompted concern. When investigators spoke with Presti, she admitted to them that she had intended to harm the 3 patients named in the initial complaint. The admission opened the door to a wider investigation that would eventually span her entire nursing career in Pennsylvania. She was arrested in May 2023 and charged initially with 2 counts of murder and 1 count of attempted murder in connection with the Chicora facility. The Pennsylvania Attorney General's office then conducted a broader review of patient deaths and serious medical events at every facility where Presti had worked during the period from 2018 to 2023. What that review produced was a picture of harm that extended far beyond what the initial charges reflected. In November 2023, the Attorney General's office announced a second round of charges, with Presti now accused of attempting to kill 19 additional patients across 5 facilities over 3 years. In total, 17 patients in her care had died. The victims ranged in age from 43 to 104. The decision about which deaths to charge as murder and which to charge as attempted murder was made on the basis of physical evidence. First-degree murder charges were filed only in cases where direct evidence, meaning the physical presence of insulin administered at a lethal or potentially lethal dose, was available to support the charge. Attempted murder charges applied to cases where the evidence showed intent and harm, but where the standard for a murder charge could not be fully met. This distinction was not a statement about the relative moral weight of what had happened in each case. It was a reflection of the evidentiary requirements of criminal prosecution and the difficulty of building a murder case around a patient death in a nursing home when the body has already been buried and the immediate clinical records attributed the death to natural causes. Presti's victims did not fit a single demographic profile beyond their shared vulnerability. They were nursing home residents, most of them elderly, most of them there because they could no longer manage their own care. But the youngest victim in the charges was in their 40s. Some were not diabetic and had no clinical reason to receive insulin of any kind. Others were diabetic and received doses calculated to kill rather than treat. What they had in common was that they were in a place where they depended entirely on the people around them, and one of those people had decided, for reasons that were never fully articulated in the formal proceedings, that they should die. Presti appeared in a Butler County courtroom on May 2, 2024, and entered guilty pleas to 3 counts of first-degree murder and 19 counts of criminal attempt to commit murder. The courtroom was full. The families of victims who had traveled to be present sat through an extended proceeding in which the structure of the charges, the names of the patients, and the nature of what had been done were formally entered into the record. Some of those family members gave statements that described what the loss of their relatives had done to them and how they understood what Presti had been doing to the people in her care. The daughter of a victim named Irene Simons, a 78-year-old woman who had not been diabetic and who had been given insulin until it killed her, said that her family would never forgive what had been done. She said that Presti had presented herself as a caring nurse while using that presentation as cover. Judge Joseph Cubitt sentenced Presti to 3 consecutive life sentences for the murder convictions. He then imposed a further consecutive term of between 380 and 760 years for the 19 attempted murder convictions. The structure of the sentence was designed to ensure that no combination of legal circumstances could produce her release. She was 41 years old at sentencing. The Pennsylvania Attorney General's office noted in its statements surrounding the case that Presti had moved between facilities in a way that the existing regulatory and licensing systems had not caught. The discipline at her first employer for improper insulin use had not triggered a board action that would have made subsequent employers aware of the concern. The deaths and medical events at each subsequent facility had not been connected to her presence there until the broader investigation forced that connection into view. Each facility saw an incident or a cluster of incidents and processed them in isolation. None of them had a mechanism for knowing that the nurse who had worked there had left a similar trail at the facility before. The isolation of institutions from each other's information is a problem that extends well beyond this case. It appeared in the Charles Cullen investigation in New Jersey and Pennsylvania 2 decades earlier, and the legislative responses to that case had not fully closed the gap that Presti exploited. The conversation in Pennsylvania, after her guilty plea, returned to questions about reporting requirements and information sharing, about what obligations a facility has when a nurse departs under a cloud of concern, and about what protections exist for the next facility's patients when those obligations go unfulfilled. 17 people died in nursing homes in western Pennsylvania between 2020 and 2023 at the hands of a registered nurse who was paid to take care of them. Most of them were elderly. Most of their deaths were processed, at the time, as the natural outcomes of serious illness in people who were already at an advanced stage of life. They were mourned by their families and documented by the facilities and moved past in the ordinary way of institutions that deal with death regularly. The investigation that eventually established what had happened to them began because a patient at one facility experienced unexplained hypoglycemia twice before dying, and because someone decided that this warranted a closer look. Before we move on, if you're enjoying this analysis, please consider subscribing. It helps the channel tremendously. From the nursing homes of Western Pennsylvania, the story crosses back to the United Kingdom, to a neonatal unit in Chester, England, where a nurse spent more than a year attacking the most fragile patients imaginable, and where a police body cam recorded the moment she was arrested at her front door in the summer of 2018. Case 9. Lucy Letby. The Countess of Chester Hospital sits on the western edge of the city, a large National Health Service facility that serves Chester and the surrounding communities, and that, in its neonatal unit, handled some of the most fragile patients that medicine encounters anywhere. Premature babies, sick newborns, infants who had arrived in the world before they were ready for it, and who needed weeks or months of specialized support before they could leave. The neonatal unit at the Countess of Chester was not a large unit by the standards of major regional centers. It was a district hospital's neonatal service, serving the local birth population and handling cases that were serious but within the range of what a well-run district unit could manage. The staff who worked there, the consultants and the specialist nurses, developed relationships with the families whose babies were in the unit for weeks at a time, relationships built on the particular intensity of caring for patients at the most vulnerable point of human life. Parents sat beside incubators and learned the rhythms of a neonatal ward and trusted the people who moved between the cots and monitors around them. In 2012, a nurse named Lucy Letby joined the unit. She had trained at the University of Chester and had sought a position in neonatal nursing from the outset of her career. By the accounts of colleagues who knew her during her years at the hospital, she was regarded as dedicated, hard-working, and genuinely committed to the work. She participated in unit social events. She was described in reviews and evaluations as a good nurse. Her managers had no formal concerns about her performance. The families of babies in her care, in the years before things began to go wrong, had no reason to view her with anything other than trust. Between June 2015 and June 2016, the neonatal unit at the Countess of Chester experienced a significant and unexplained increase in the number of babies who died or suffered sudden and serious collapses. The consultants working in the unit began to notice the pattern. The deaths were clustering. The timing of the collapses was unusual. In a unit that had been operating without a death for a sustained period before 2015, the sudden appearance of multiple deaths in a compressed time frame demanded an explanation. The doctors raised their concerns through internal channels. They flagged the pattern to hospital management and argued that an external investigation should be commissioned. The response from hospital administrators in the early period was slow, and this slowness would later become the subject of a separate criminal investigation. The consultants were persistent. They compiled data. They drew up schedules and overlays and pointed at the numbers. What they were pointing at, the information they were putting before hospital management, was a correlation between periods when a specific nurse was on duty and periods when babies died or collapsed. The nurse was Lucy Letby. The hospital eventually commissioned a review, and police were eventually notified, and a major investigation by Cheshire Constabulary began. Officers spent years collecting evidence from the neonatal unit, reviewing the medical records of every baby who had died or suffered a serious collapse during the relevant period, examining the staffing rotas, and working with medical experts to understand whether the clinical events in question could be explained by natural causes or by the underlying conditions of the babies involved. On July 3, 2018, officers went to Letby's home in Chester. The footage of what happened that morning was later released by Cheshire Constabulary, and it was widely broadcast, a body cam recording showing the moment Letby was arrested at her front door. She was informed of the arrest. She was taken from her home. The footage became the public visual record of the end of the investigation phase and the beginning of the legal proceedings against her. She was 30 years old. She was released under investigation while the evidence review continued. She was rearrested and interviewed further. She maintained throughout that she had never harmed a child in her care. At no point in the years of investigation and the subsequent trial did she change that position. The trial opened at Manchester Crown Court in October 2022. It would run for almost a year, making it one of the longest criminal trials in modern English legal history. The prosecution case rested on several categories of evidence. Medical expert witnesses testified about the manner in which each baby had died or collapsed, arguing that the clinical presentations were not consistent with natural causes given the baby's underlying conditions and the course of each event. Staffing rotas placed Letby on duty at the relevant times. A statistical analysis of deaths and collapses during her shifts formed part of the background context for the case, though the prosecution's primary argument was not statistical, but clinical and circumstantial. Investigators had found a handwritten note at Letby's home during a search of her property. The note was fragmentary and difficult to interpret with certainty. It contained phrases that the prosecution characterized as expressions of guilt and self-accusation. Letby, in her evidence, offered an alternative account of when and why she had written it, saying she had written it during a period of distress after she was placed on administrative duties and removed from the ward, and that the words reflected her emotional state at that time, rather than an acknowledgement of wrongdoing. She gave evidence over several weeks. She denied every allegation. She said she had loved working with the babies in the unit. She said it was devastating to discover that she had been blamed for the deaths. She suggested that a group of consultants had, for reasons of institutional self-protection, identified her as a target in order to deflect scrutiny from the hospital's own failures and from the quality of care it had been providing. The jury deliberated for 22 days, spread across several separate hearings, as additional verdicts were returned at different points in the process. On August 18, 2023, the full set of verdicts was reportable. Lucy Letby was convicted of murdering 7 babies and attempting to murder 6 others. She was acquitted of 2 counts of attempted murder. The jury did not reach verdicts on 6 further counts. She refused to appear in the dock for the reading of the verdicts and was represented instead by her legal team. A hearing before Justice Goss followed, and on August 21, 2023, Letby was sentenced to whole life orders on each of the murder counts, meaning she will spend the rest of her life in prison with no possibility of release. The sentence was 15 consecutive whole life orders. A retrial was ordered on the 6 counts on which the jury had not reached a verdict. A second jury, hearing the evidence on a single count relating to a baby known as Child K, returned a guilty verdict in July 2024. Letby was found guilty of attempting to murder Child K by dislodging her breathing tube. The prosecution alleged that she had done this on 3 occasions across a single night. A doctor who had walked into the room testified that he had seen Letby standing next to the incubator doing nothing as the baby struggled. Letby, in this second trial as in the first, denied everything. She is currently serving her sentences at a women's prison in England. The case did not end with the verdicts. In the years following the conviction, significant questions were raised publicly about the reliability of the evidence on which it rested. The New Yorker published an extended investigation in May 2024, examining the medical evidence used at trial and presenting the views of clinicians who argued that the deaths and collapses attributed to Letby were consistent with natural causes given the baby's prematurity and underlying conditions. The Guardian, Private Eye, and other publications reported on concerns about the statistical and medical analysis. A group of international medical experts held a press conference in early 2025, at which they disputed the evidence that had been placed before the jury, arguing that the conclusions drawn from the clinical presentations did not withstand scrutiny. Letby's lawyers lodged a formal application for review with the Criminal Cases Review Commission, the body in England and Wales that examines potential miscarriages of justice and has the power to refer cases back to the Court of Appeal. That application was pending as of the summer of 2026. Her legal team has argued consistently that the conviction should not stand and that the medical evidence at trial was insufficient to support the verdicts returned. It should be stated plainly that these questions have not been resolved. The convictions are legally upheld. The Court of Appeal has not overturned them. The Criminal Cases Review Commission has not yet reported on the application before it. What exists is a conviction returned by a jury after a lengthy trial, and alongside that conviction a body of expert opinion arguing that the evidence on which it rested was not reliable. Both of these things are true simultaneously, and neither cancels out the other in the absence of a formal legal finding. What is not in dispute is the experience of the families. 7 babies died in the neonatal unit at the Countess of Chester Hospital during the period in question. 6 other babies suffered serious collapses from which they recovered. The parents of those babies went through something that no account of a trial or an appeal or an expert dispute can adequately capture: the particular anguish of watching a newborn child fail and not understanding why. For those who are convinced by the conviction, the answer to that question is Lucy Letby. For those who find the evidence disputed by the international experts persuasive, the question of what actually happened to those babies remains unresolved. The separate investigation into the hospital administrators, who were warned by consultants and moved slowly, is a thread that runs parallel to the criminal case and has not yet concluded. Cheshire Constabulary launched an investigation into potential corporate manslaughter at the Countess of Chester Hospital in October 2023, focusing on the decision-making of senior management in response to the consultants' concerns. 3 former leaders of the hospital were arrested in 2025. Their cases were under ongoing investigation as of the summer of 2026. Whatever the final determination of those proceedings, the record of how the hospital responded to its own clinicians' alarm over a period of years is part of the full account of what happened in that neonatal unit. The bodycam footage released by Cheshire Constabulary, showing the moment of the arrest at Letby's front door on a summer morning in Chester in 2018, became one of the most widely reproduced images of the entire case. It shows an ordinary-looking house on an ordinary street, and a person being formally informed that she is under arrest, and the legal process beginning. Whatever the ultimate resolution of the questions raised about the conviction, that footage is the public record of the moment the investigation became a prosecution, the visible hinge point between years of internal hospital concern and the formal machinery of the criminal law. The neonatal unit at the Countess of Chester Hospital has continued to operate. The families of the babies who died have spoken publicly at various points about their experiences, about the years of uncertainty before the trial, about what the conviction meant to them, and, for some, about what the subsequent expert disputes have done to the certainty the verdict briefly gave them. There is no simple resting point in this case. It continues to generate examination and argument in ways that most criminal convictions do not, and it will continue to do so until the Criminal Cases Review Commission reaches a conclusion on the application before it. Before we move on, if you're enjoying this analysis, please consider subscribing. It helps the channel tremendously. From the neonatal unit in Chester, the story crosses the Pacific one final time to a hospital in the city of Kashiwa in Chiba Prefecture, Japan, where a nurse entered a patient's room at 4 in the morning on a January night in 2026, stayed for about 60 seconds, and left behind something that killed him the following day. All of it captured on the hospital's security cameras. Case 10, Miyuki Furukawa. On the night of January 29, moving into the early morning of January 30th, 2026, a 51-year-old nurse named Miyuki Furukawa was working the overnight shift at Kashiwa Tanaka Hospital. She was the senior nurse on duty for her floor that night. One of the patients in her care was a 75-year-old man named Eiji Aita, who had been admitted from his home city of Toride, in Ibaraki Prefecture, adjacent to Chiba. Aita was hospitalized for medical treatment, and by the accounts of hospital staff speaking after his death, he had been fully capable of normal conversation until the day before his condition deteriorated. He was not a patient whose death was imminent. He was not at a stage where his family had been called to the hospital to be present in the way that happens when clinicians expect someone to die soon. He was receiving treatment, and, until the early morning hours of January 30th, he was managing. At approximately 3:55 in the morning, something changed. The hospital at Kashiwa Tanaka had security cameras installed in its corridors. The footage from those cameras on the night of January 29 to 30 captured a sequence of events that investigators would later describe as central to their identification of a suspect. The footage showed Furukawa entering Aita's room at around 3:55 in the morning. She remained inside for approximately 1 minute. She then left the room. Roughly 5 minutes after she exited, an assistant nurse who was making rounds through the floor on her standard patient checks arrived at Aita's room. What she found when she entered was a patient in visible distress. His face was pale, his breathing was shallow. She noticed something else immediately. The liquid inside the IV extension tube running from Aita's arm had changed color. It had turned brown. Intravenous fluid is clear. The solution running through a patient's line should be transparent, colorless, carrying whatever medication or saline has been prescribed through the plastic tubing without visible contamination. Brown is not a color that belongs in an IV line under any normal clinical circumstance. The assistant nurse raised the alarm. Medical staff responded. Aita received treatment, but his condition continued to deteriorate across the following hours. He died at approximately 10:30 in the evening of January 31, 2026, a day after the episode in his room in the early hours. The cause of death was established as multiple organ failure resulting from sepsis. When pathologists examined his blood, they found bacteria of the kind commonly associated with human fecal matter. A foreign object was recovered from the IV extension tube. Investigators examining the tube found that the contaminating substance appeared to have been introduced through a side port, a small access point built into IV extension lines precisely to allow medication to be administered without disconnecting the primary line. The port is designed for clinical use, accessible with a standard medical syringe. Investigators who reviewed the timeline and the footage and the physical evidence from Aita's room formed the view that what had happened was deliberate. The brown discoloration in the line, the bacterial findings in the blood, the location and nature of the contamination in the extension tube, and the sequence captured on the security cameras all pointed toward a conclusion that human waste had been introduced into Aita's VOR system during the approximately 60-second period when Furukawa had been alone in his room in the early hours of the morning. The hospital reported the suspicious death to police on February 1, 2026, 2 days after Aita died. The Chiba Prefectural Police began an investigation. Investigators reviewed the security camera footage from the night in question. They mapped the movements of the staff on duty. The floor where Aita was being treated had 2 nurses responsible for its patients that night, and the footage from the cameras was specific enough to establish a sequence that, combined with the physical evidence from the room and the IV line, focused the investigation in a particular direction. Additional details emerged during the investigation that strengthened the picture investigators were developing. Staff at the hospital told investigators that Furukawa and Aita had previously had a difficult relationship. There had been at least one argument between them. The nature and cause of the dispute was not fully detailed in the public reporting of the case, but investigators noted that there appeared to be a prior grievance of some kind, which they flagged as a potential element of motive in trying to understand why what happened had happened. Investigators also examined Furukawa's digital activity. On her smartphone, they found search queries that she had run in the period before January 30th. The searches asked, in various phrasings, whether injecting feces into a person's body could kill them. One query was reported in Japanese media as asking directly whether putting feces into an IV drip would be fatal. Another asked whether injecting stool would kill someone. The searches had been conducted and returned results before the night Aita died. Investigators took the position that the searches represented deliberate research into the lethality of the method she was subsequently alleged to have used, rather than incidental or coincidental internet activity. Furukawa had moved the IV extension tube from Aita's room to a staff area while he was being treated after the assistant nurse raised the alarm. This detail, documented in the investigative record, was noted by police as significant. Moving the physical evidence from the scene of the incident before it could be examined by arriving medical staff is not an action consistent with the behavior of someone who did not know what was in the tube, or someone who had not put it there. She was suspended from her position at Kashiwa Tanaka Hospital immediately after the incident. At the end of February 2026, having been informed that the police had opened a formal investigation, she submitted her resignation. She then took employment at a hospital in Tokyo, working not as a floor nurse, but as a midwife. She had additional professional qualifications in midwifery beyond her general nursing training, and she used those qualifications to continue working in healthcare after leaving the Kashiwa facility at a different institution in a different part of the greater metropolitan area. On July 15, 2026, Chiba Prefectural Police arrested Miyuki Furukawa on suspicion of murder. The arrest came approximately 5.5 months after Eiji Aita died. She was taken into custody in Tokyo, where she was working at the time. The arrest was reported by major Japanese news organizations and generated significant public attention, both because of the nature of the alleged method and because of the online searches investigators had found on her phone. During questioning following her arrest, Furukawa denied the allegations. She told investigators that she had not mixed anything into Aita's 5V tube. She said it was something she knew nothing about. Her denials were consistent and direct. She has not, as of the time of this case being reported, offered an alternative explanation for the footage showing her entering the room in the minutes before the assistant nurse found the patient in distress, or for the search queries found on her phone, or for her decision to move the IV tube out of the patient's room during the emergency response. Her legal position, as conveyed through the reporting of her statements to investigators, is that she did not do what she is accused of doing. It is important to state clearly that Furukawa has not been convicted of any offense. The arrest occurred days before this case is being described. The Japanese legal process requires that prosecutors decide within a specified period whether to formally indict, and that decision had not been publicly reported at the time of writing. Everything described here that relates to her alleged actions is based on what investigators have stated publicly and on what has been reported in Japanese media, drawing on investigative sources. The case is active, the proceedings are in their earliest stage, and the full legal determination of what happened at Kashiwa Tanaka Hospital on the night of January 29 to 30, 2026, has not been made. What can be established from the public record is the following. A patient named Eiji Aita was 75 years old and was receiving medical treatment at a hospital in Kashiwa. He was capable of normal conversation the day before he died. He died of sepsis, caused by what pathologists determined was contamination of his bloodstream with bacteria associated with human waste. Security cameras at the hospital showed a nurse entering his room for approximately 1 minute in the early hours of January 30th, 2026, and the patient was found in serious distress minutes after that nurse left. The nurse in question had conducted online searches asking whether injecting feces could kill a person before that night. The nurse moved the contaminated IV tube from the patient's room during the emergency response. The nurse resigned from the hospital after learning that a police investigation had been opened and continued working in healthcare at another facility until her arrest. The hospital's operating corporation, Oikai, released a statement after the arrest, condemning what it described as an absolutely unforgivable act for a healthcare professional and for a person. The statement offered an apology to those affected and expressed the corporation's full cooperation with the investigation. The director of Kashiwa Tanaka Hospital, Tomonobu Hasegawa, also addressed the media, apologizing for what had occurred and stating that the hospital would reinforce its ethical training for all staff. The hospital remains in operation. Eiji Aita was from Toride City in Ibaraki Prefecture. He was 75 years old. The reporting on his case does not describe the circumstances of his admission in the detailed way that longer established cases allow, because the case is new and the investigative record is still being compiled, and the legal proceedings that might produce a fuller public account have not yet begun. What is known is that he was in a hospital in Kashiwa, that he was not at the end of his life in any anticipated clinical sense, and that he died on January 31st, 2026, the day after the events on his ward in the early hours of the morning. The security cameras at Kashiwa Tanaka Hospital that recorded the relevant footage had been installed as part of the hospital's standard security infrastructure. They were not placed there in response to any suspicion about any particular member of staff. They were running that night because they were always running, recording the ordinary movements of a hospital working through the night, capturing nothing of significance on most of the nights they operated. On the night of January 29 to 30, 2026, they recorded something that investigators determined was not ordinary. The footage was preserved and reviewed and became, along with the physical evidence from the IV line and the digital records from a mobile phone, the basis on which a 51-year-old nurse was identified as a suspect in the death of a 75-year-old patient. The case is before the Japanese legal system. Its outcome is not yet known. If you enjoyed this breakdown, make sure to subscribe. Thanks for watching, and I'll see you in the next one.